The U.S. Supreme Court just heard a case about Colorado's ban on conversion therapy for minors that could have massive implications for queer people in the U.S. in the years to come. The court heard arguments today in a case brought by Christian talk therapist Kaley Chiles against the state of Colorado. In the suit, Christian law firm Alliance Defending Freedom argued that Colorado's ban violates her First Amendment rights to discuss her faith with her patients. And the state's lawyers argue that this argument is not rooted in reality, but rather based on a hypothetical infringement of free speech. The state claims it has not received a complaint about Chiles' professional conduct, nor has she been disciplined. And questions asked by the court's conservative justices appeared to sympathize with Chiles' free speech claims, while the court's liberal justices seem to align with Colorado's argument that they have the right to ban a practice they deem unsafe and ineffective. The court currently has a conservative majority with only 3 justices appointed by Democratic presidents, compared to 6 justices appointed by Republican presidents, including 3 by Donald Trump alone. And based on the tone and tenor of the oral arguments heard today, it's possible the court's majority finds that Colorado is trying to regulate speech unfairly, rather than what the state argues, which is that it's regulating professional conduct in a healthcare context. Essentially, how free speech is interpreted in this case is the foundation of whether the conversion therapy ban will be rejected by the court. And let's be clear here, conversion therapy has been condemned by a long list of major medical organizations and experts. Research has routinely found that not only does the practice not work, it significantly increases a person's likelihood to develop feelings of depression or suicide. And in support of the state's argument, liberal Justice Ketanji Brown Jackson used the court's ruling allowing states to ban gender-affirming care for minors from earlier this year to illustrate a potential double standard if the case goes the other way.
I'm wondering why this regulation at issue here isn't really just the functional equivalent of scrimetti. It just seems odd to me that we might have a different result here.
Now, if the court does rule against the state, it will likely have implications for the 23 other states that have similar bans, and it could set a precedent for other long-standing healthcare regulations that are determined on a state-by-state basis. Later this fall, the court will consider 2 cases regarding trans athletes in women and girls sports. And while Supreme Court decisions could come in as early as December if they are unanimous, we might not actually get anything official until the summer, given the likelihood for dissension in these cases.